Good afternoon or morning, as it may be for some of the listeners. We do appreciate all of you taking the time to join this discussion. My name is Calvin Shannon, and I'm a tax partner with BGM, a CPA firm. My firm provides tax audit and consulting services to a significant number of cannabis operators throughout the country. In light of some recent news, which we'll get into more as this conversation proceeds, a lot of our clients have reached out to us with questions about what it means for the industry and what it means for their organization specifically. So we reached out to Nick Richards with Greenspoon Marder to see if he'd be willing to participate in a webinar and try to help us answer some of these questions, and Nick graciously was willing to do so. With that, I'll let Nick introduce himself.
Calvin, thank you, and thank you BGM as well. A great quality firm, and I'm happy to be associated with you guys. I'm a partner at Greenspoon Marder, a AmLaw 200 law firm, a full-service law firm with about 25 offices across the United States. We're big in the cannabis space, one of the first big firms to have a dedicated cannabis practice, and we have many cannabis clients. Personally, I've been involved in the cannabis industry since 2012, which was shortly after I left the IRS, where I was an IRS trial attorney for about 11 years or so, and got my first 280E audit for a very small company here in Denver in 2012. I'll never forget it. You know, Calvin, I thought, gee, this is really kind of a weird area of the law, pretty interesting. And, you know, that was the start. And now here we are, more than 10 years later, is pretty much a huge part of my practice. My main practice is tax controversy, trials and audits and litigation and debt and all that fun stuff. I also help cannabis companies get it right. And a very important thing when you're just getting started and you don't understand 280E, which is kind of our topic today, but not really. So Calvin, thanks so much. I'd like to say hi to everybody out there. Calvin, I saw a lot of our friends and colleagues and people on the webinar today. So it's great to see such great turnout.
Yeah, we do have a fantastic audience, and I agree with your points about the working in this industry has been a journey and a great opportunity to learn a lot and make a lot of mistakes to learn from. So, yeah, thanks, Nick, for the introduction. And again, thank you very much for taking the time to have this discussion. We'll go ahead and jump into some of the questions that we're hoping to get a better understanding of. Before I do that, I'll make one comment for the listeners. To the extent that you have any questions that you'd like us to address, to the extent we have time, please feel free to go ahead and submit those to the Q&A part of the webinar, and as we move along, and to the extent time allows, we'll try to get to some of them.
Hey, Calvin, I should probably make a quick disclaimer too. So this is this webinar and the information we're going to give is informational. We don't have inside information here, secret information from the IRS or Trulieve or any of that kind of stuff. And so we're not giving out advice here. We're just having a discussion, and the information that we're going to provide is informational, not advice. Thanks.
Yeah, that's a great point. Thanks for mentioning that, Nick. Well, we've all heard a lot about the news of Trulieve's amended returns to claim refunds of approximately $143 million back in October, and then more recently we've heard some news that they received a significant portion of that. I think it's 113 million of those refunds from the IRS. And while I know that you're not representing Trulieve, and you likely wouldn't know the specifics of the position that particular taxpayer took, I guess I was hoping if you'd be willing or able to give some theories or your thoughts about the position. And it's a big question, I know, and so yeah, I know a lot of people are really curious about this. So maybe share whatever you may know or whatever theories you may have.
Yeah, so I think that so Calvin, there's another case out there called Canna Provisions. That is a district court case in Massachusetts that lays out a bit of the argument. But I believe that the basic position is that a case called Gonzalez v. Raich is no longer good law, or if it came before the Supreme Court, that Gonzalez v. Raich would be overturned or found to be not applicable to a current cannabis industry taxpayer. Gonzalez v. Raich is an old case. It's a 2005 case, and at issue in Gonzalez v. Raich was whether, after California legalized marijuana for adult use, whether the federal government could continue to schedule it as a scheduled controlled substance. Calvin, it's kind of funny, right? The only thing that gives the federal government the power to regulate drugs is something called the Interstate Commerce Clause. There is no specific power to regulate drugs in our U.S. Constitution. And generally, if there isn't a specific grant of power to the federal government, the power is reserved for the states under the 10th Amendment to the Constitution. But over the last maybe 100 years or so, this Interstate Commerce Clause has kind of been expanded to kind of fill some sort of practical holes in our system. For example, environmental laws are authorized under the Commerce Clause. And, if you think about it, if I'm in Colorado throwing pollutants into the Arkansas River, and they're not causing a problem until they get downstream to Arkansas, then Colorado doesn't really care. I'm not in Arkansas, it's intrastate activity, but the federal government needs to have the ability to kind of regulate that kind of activity. And so the Commerce Clause has been expanded over the last 100 years to kind of give the federal government some sort of practical ability to regulate areas that aren't interstate commerce and instead are what are known as intrastate commerce. And so there's a line of cases that holds that the federal government has the right to regulate intrastate commerce that has a substantial effect on interstate commerce. And that was the line of cases that was relied upon in Gonzalez v. Raich, along with a very specific factual finding. That factual finding was that the federal government couldn't give California an exception to the Controlled Substances Act for marijuana, because if they did, it would basically turn the Controlled Substances Act into Swiss cheese and eviscerate it and make it ineffective for the federal government. Corey, 20 years later, I'm sorry, Calvin, 20 years later.
I've been called worse, I promise.
The Corys and the Calvins kind of on the same space in my head. Both very smart CPAs. 20 years later, things have changed, right? The facts have changed fairly dramatically, and that was the subject of Justice Thomas's comment in a case called Standing Akimbo about maybe a year and a half ago. That uniform illegality that was necessary for the holding in Gonzalez v. Raich, there's no uniform illegality anymore out there. The federal government is hands off if you're in a state that has legalized marijuana. And we see that through various announcements and et cetera over the last years. Cole Memo is one example. Rohrabacher Farr Budget Writers is another one. The expansion of the cannabis industry into 37 states for medical, 24 for adult use. This kind of stuff has changed that fact of uniform illegality. And then the other thing that has changed is the law is in a process of change as well. The Interstate Commerce Clause, the current court does not approve of that expansion that I described. And they're kind of turning the other way on that, and they're pulling back on that expansion. And we haven't seen a substantial effects case in quite some time. And there are some cases out there that go a different route, suggesting that the Supreme Court jurisprudence has changed around the Commerce Clause. The other thing that has changed is the Supreme Court has announced that it's going to overrule precedent that doesn't honor the original intent of our Constitution. And there's nothing further afield from the original intent of our Constitution than the Interstate Commerce Clause. And so it appears that it's ripe to be overturned or found to be not applicable to the current cannabis industry. And the current court, which is 6-3 conservative, leans heavily towards states' rights rather than expansion of the Commerce Clause to ensure federal rights. And so for that reason, Calvin, we think that there's a reasonable basis for the argument. Doesn't mean it's right, could still lose, but we do believe that it's not frivolous and that it is a reasonable argument that Gonzalez v. Raich may no longer be good law. And Corey, let me just finish. If Gonzalez v. Raich is no longer good law, then marijuana is no longer scheduled under the Controlled Substances Act, and Section 280E, which requires a Schedule 1 or 2 controlled substance, no longer applies. Thus,
Yes.
the Trulieve refunds.
That all makes sense, and it certainly seems like a plausible argument, and your qualification that how it'll actually turn out, or the pushback from IRS and how it'll work out is certainly up in the air, but it seems to be the start of a well-formulated argument for sure.
Yeah, it's definitely an argument that finds support, and it is it's not a frivolous argument. It still may lose, but when you can get to a reasonable basis in an argument, it allows a company to take a position on a tax return according to that reasonable basis, disclose it to the IRS, and then not be subject to penalties. Calvin, our system's complicated, and it recognizes that taxpayers should be able to take a contrary position to where the IRS might be and disclose it, do it in a responsible way, and in exchange not be subject to penalties. And that's really what the industry is doing here. It's trying to do this in a responsible way and to take a path that it believes may lead to non-applicability of 280E, which is a big thing. I believe they're willing to take that to the end and get a Supreme Court decision, hopefully overturning Gonzalez v. Raich.
Yeah. Well, continue down this line of thinking. If a taxpayer was going to take a position or a position similar to this, the logistics of it, what would you advise regarding the need to obtain a tax opinion from an experienced and qualified tax attorney to support this position? How critical would that be?
Calvin, I think that's important for any company of any real size, right? You want to, if you're an executive at a company, you want to protect yourself from making decisions around taking tax positions that could be wrong. And the way you do that is through a tax opinion and disclosure on the tax return as well. Generally, the way that works is that the tax opinion goes in the taxpayer's file, and then the disclosure is, say, a summary of that opinion that goes on the tax return itself. And then that process it protects the taxpayer and the return preparer from penalties should that position turn out to be incorrect.
Certainly want to try to get some protections for us tax preparers as well.
That's right. We're really looking out for you guys.
Do appreciate that. Okay, well, assuming that a taxpayer was going to take position, what would the logistics look like? Assumingly, the taxpayer would file amended returns for all tax periods that are still open, and then you use I guess take a similar position for unfiled tax returns on a go forward basis.
Yeah, I mean, every taxpayer has to make that decision independently, right? Generally speaking, though, you can file an amended return within 3 years of filing your original return, and so that probably means that 2020 may still be open for an amended return, depending upon how soon you file in your 2020 return. But for most people, they file in the fall, so that's probably still open. And then, you don't have to do that. There could be some reason why you don't want to file an amended return. Maybe the benefit is insignificant. Maybe you don't want to open up that year for audit, because when you do file an amended return, now there's an additional 3 years that the IRS can audit you after filing that amended return. Calvin, it seems unlikely that somebody who takes that position on an amended return wouldn't also take that position on a go forward basis. So I think we're going to see most companies do that. I was reading through Trulieve's announcements in their 10K and whatnot, and it seems like that's where they're going to go as well, because they talked about how their reserve is going to increase with future years. And, if you believe that the Gonzalez v. Raich was no longer good law for your amended returns, that doesn't mean it's no longer good law for your your going forward return. So I think we'll see that from much of the industry. And then, of course, Calvin, that then paves the road a little bit for what your estimated tax payments are moving forward and other things like that as well. So it has a number of different effects.
Yeah, no, absolutely. So swinging back to the refunds that that Trulieve had announced that they'd gotten, and frankly, I was floored with surprise
Yeah.
when I had heard that, and obviously that spurred a lot of questions from some of our clients. I guess my question is, to the extent somebody or a taxpayer was going to take this position, would you have warning for them that just because Trulieve received their refunds they asked for, or a portion of it, could that necessarily be every taxpayer's expectation?
Yeah, I think anybody who takes this position should assume they're going to get audited and they're not going to get their refund. If they do, great. But I would never want to assume that you're going to get that refund. I think that we hear Trulieve got their refund. I'm sure they did. That doesn't mean they're not also going to get audited. The IRS still has 3 years to do that. And generally the IRS wants to issue refunds because if they don't, and it becomes correct, then they'll have to pay interest on those amounts. And so generally they will issue refunds, and then if they want to audit you, they will. And if they're right and you're wrong, then they'll ask for that money back plus interest, right? So that I think that's kind of what we get out of it. You could start to walk down a road of, well, somebody had to approve that refund. And Calvin, I think the Internal Revenue Manual would say that it was the Joint Committee on Taxation that had to approve that refund. I don't know how much we heard. Well, we heard from Trulieve that they got that refund in the fourth quarter, which would be pretty quick. So I don't know how much review was actually done by the IRS before the refund was allowed. I want to say that if the IRS believed that the argument was frivolous, that they probably would not have issued that refund. I want to say that. I'm not sure that that's exactly correct, but I want to think that there was at least a certain level of review that occurred. And because of that level of review, the IRS got to the position of, well, this may work. We should issue the refund so that we won't have to pay interest if it does. And now we can look at whether we're going to open up for them up for audit or not. And I would imagine that's going on right now inside the IRS. They're looking closely at the position and figuring out what to do.
Yeah, it kind of leads into another question that I had. And, let's assume a lot of taxpayers start taking these positions, filing amended returns, filing his returns that look like this on a go-forward basis. Do you have any thoughts about what the IRS's temperament towards this movement? I don't know, to this happening, if it's an increased number of taxpayers taking a position with amended returns and go-forward returns, do you think that'll will it have an impact on the IRS or their temperament, or do you think they'll notice?
Calvin, we still run into that person all over the place, which, the very first thing they have to tell you is that they didn't smoke in high school, that kind of attitude. And I think that there is still a lot of sort of prejudice against the cannabis industry, frankly. And, in the many 280E audits that I've handled, I've run into IRS personnel that say this is wrong. I can't believe that this 280E applies, and can't they just legalize it? And I just have to do my job, but I'm not happy about it. And then you meet people sometimes that it seems like they kind of want to hurt your client, right? And so it's hard to understand what you're going to get before you start to see it. Like I said, I think you have to assume the IRS is looking closely at this. And I think you have to assume that they're going to audit Trulieve. And if you're considering doing this, that you have to assume that you're going to get audited as well. It's a pretty sound legal position though. So it's really going to come down to, the argument over the position and whether Gonzalez v. Raich is still good law. And that, Calvin, that probably means we got to get up to the Supreme Court until we really have an answer on this.
Yep. So the fight needs to happen. Just whoever's wanting to participate in the fight, just go into it eyes wide open, knowing that very well may be what they're getting into.
Yeah, that's right.
Penalties and interest. Probably some curiosity about that. What filing amended returns, getting refunds, maybe not. Filing returns on go-forward basis, reducing the amount of tax, that estimated tax or tax with returns that's paid in. It certainly could result in some penalty, probably certainly some interest if the IRS was to successfully push back on the position, possibly mean some penalties. Can you speak to or give your thoughts on penalties and interest?
Yeah, so interest is statutory. You can't really get out of interest. If you owe tax, you owe interest. That's just all there is to it. Penalties are different. There's different relief for penalties. And the one that we talked about earlier, Calvin, is disclosure, right? Disclosure of the position on what's called a Form 8275. Gets you out of penalties, particularly the negligence penalty. There could be some failure to pay penalties and some things like that could be triggered still, but it gets you out of the big negligence penalty that tends to apply when you take a position that the IRS feels is negligent. So that's the purpose of a tax opinion and the disclosures that go on the tax return itself. Calvin, there's also reasonable cause as well, aside from all of that as well. If you can show that, basically you acted within a responsible and reasonable manner, and that nevertheless, due to circumstances beyond your control, a tax went unpaid. You dealt with it responsibly after that happened. In those kind of circumstances, you can get out of penalties. And there's also first-time penalty abatement as well. So there's a lot of different ways to get out of penalties. And Calvin, I'm reminded of some of the very early tax cases, I think all the way up through Patients Mutual, where the court basically said that penalties aren't applicable in the 280E world because it's complicated. There are no regulations or guidance on it. And for that reason, taxpayers shouldn't be held subject to penalties. That said, there's been a lot of them that have.
Yeah. So the thought being penalties are potentially an issue. We're hoping to position ourselves, like you said, with the opinion and appropriate disclosures to the IRS to get out of them. Interest, really not a way to get out of that if you do end up owing the tax. That said, and I always do mention this, that in the cannabis industry, the borrowing rate is often quite high. So the IRS's interest rate may even be a good option to take. But
yeah, I think it's about 7.5% right now.
Yep.
Maybe it's up to 8%. It's right in that ballpark.
Certainly not high as a lot of license holders are paying for other debts. So
yeah.
I wanted to discuss a little bit about the types of taxpayers taking the position may or may not be a fit for, and how that relates to taxpayers using that would be eligible to take the position that they're accounting for inventory using 471C and characterizing some costs that would otherwise be disallowed as inventoriable costs and cost of goods sold. Would a taxpayer like that, and obviously each taxpayer is different and analysis needs to be done about their specific situation, but do you think there'd be some cases it would be better for a taxpayer to use 471C to mitigate 280E rather than this approach with descheduling and the Commerce Clause?
Calvin, we're seeing success on 471C method taxpayers whose books and records match their tax return. We've gotten some no change audits from the IRS. It's not over. There's no tax case on it or anything like that yet, but people are seeing success there, and it's not just me that's getting no change letters as well. So I think that's a valid question. I don't think, though, that they are mutually exclusive either. I think a win for Trulieve, shall we say, is a win for 471C as well. And so if you are a small business taxpayer, 471C is available to you regardless of what kind of taxpayer you are. It's not just for cannabis, right? It is the small business exception to the inventory accounting rules. And one of the real powerful things about 471C is that if you meet the rules, meaning that your books and records, your general ledger, right, matches your tax return. Calvin, I'm not a CPA. I'm not an accountant. I want to see the same numbers, right? Here's the P&L. There's a number on there. I want to see that number on the tax return as well, right? I don't want to have to call you up to figure out how I got there, you know? And if that's the case, then under Section 471C, that tax return clearly reflects income by law, which is a remarkable thing in our tax system. Usually it's the IRS that gets to say what does and doesn't clearly reflect income. And, you know, they'll change a relationship between related parties. They can force a change of an accounting method. They can do a lot of things if they believe that the taxpayer's return doesn't clearly reflect income. Here on 471C, the method clearly reflects income by law, which is really important to know. It is by law. It's not a regulation. It's not a method. It is the law. And so if 471C contradicts another accounting method, let's call it GAAP, guess who wins? 471C. GAAP is not the law. GAAP is a method, and GAAP doesn't. You're a public company. So if there's a conflict between the law and a regulation or a method, the law wins, right? And 471C is the law. So I do think there could be a strong position taking the Trulieve method in a 471C method taxpayer. I think that's a pretty strong position to take.
No, that makes sense, and something that certainly I'm sure a lot of taxpayers will want to have further discussion about.
Mm-hmm.
The last, I guess, question that I had before we jump into what appears to be 22 questions. So I was going to ask about, assuming a taxpayer didn't want to take this aggressive but seemingly reasonable position, the Trulieve method, you just characterized it. Should taxpayers consider doing protective claim amendments to hold statutes in case that there is a resolution in the industry's favor out into the future, and then be able to go back and do those amendments later?
Yeah, I think that's definitely a consideration taxpayers should make. A protective claim is the same as a claim for refund, but basically you take your 1040 or 1120X or 1065X or whatever your amended return, and at the top in red ink you write protective claim for refund. And then when that shows up in the IRS's inbox, it satisfies the 3-year filing date statute, but the IRS doesn't do anything with it. They just hold it. And then every year you get a letter that says, hey, dummy, we got this tax return. What do you want us to do with it? Do you want us to go ahead and process it, or do you want to withdraw it? So it has an element to it that you think something may happen, and for that reason you're protecting the statute. And if it does happen, then you'll ask the IRS to process the return. And it's another part of our system that recognizes that, taxes are complicated and things can happen, and taxpayers should be able to protect their ability to benefit from those things if they do happen by preserving the statute of limitations. So yeah, I do think it's an important tool in the discussion.
Yeah, it makes me think of, I guess, one more quick follow-up question. Filing a protective claim, you're not asking for a refund. Supporting the position, even taking on a protective claim, the necessity, well, I guess, what's your opinion on the necessity of having a tax opinion for that, or is, listening to a conversation like this, adequate support to proceed with a protective claim?
Yeah, again, I think it has to do with the size of the taxpayer. But you can't file a protective claim that's frivolous either. And so I think that an opinion could be necessary there. Plus, if you're going to file a protective claim, what are you going to do going forward, right? Are you going to take the position going forward, or are you going to continue to file regular 280E returns and then file protective claims as well? So I think there's a discussion around that. It could be that a tax opinion is useful in other ways, as well as supporting the protective claim for refund. And I would still put a disclosure on those protective claims as well, a Form 8275 with a complete disclosure.
Yeah, that makes good sense.
Yep.
All right. Well, why don't I now to 26. Try to scroll to the bottom of the questions here. Or I'll just start at the top, I guess.
Chevron. Yeah, I see that one, Calvin, about Chevron. Chevron does apply in the tax context. Although, is it still good law? Chevron might be overturned, right? So the answer to that is yes, it applies.
How does the mere possible, maybe I'm missing the rest of the question here. It got cut off. I think that question got cut off. Well, I'll move on to this one. Do you think the HSH Schedule 3 recommendation impacts, or well, they'll just say impacts the Trulieve argument?
I don't think it does. I do believe it's another fact showing the federal government is not interested in regulating marijuana under the CSA. But I don't believe it's one of the reasons for the refund requests that were made. That HHS recommendation in the report has a lot of interesting information about it. Calvin, if it's not suitable for Schedule 1 now, it wasn't suitable for Schedule 1 20 years ago either, right? Finally, we get a report that actually sets forth the truth about cannabis, and the truth is that it was misscheduled from the start. So I think there's an argument to be made there, that the federal government sort of now admits that, and maybe that's another sort of factual argument to make in supporting the argument that Gonzalez v. Race is no longer good law.
I'm reading a quite lengthy question. I'm going to summarize it at a real high level. The question, I guess I would summarize as medical license holder versus adult use license holder. What would that mean for this argument? Would it be impactful or matter at all?
So I believe that Trulieve is predominantly medical. I don't think they're exclusively medical, but I believe they have a pretty big medical, because they're in Florida, and Florida is a medical state, and I think they're in some other medical states as well. Calvin, I think the facts might be a little bit better for medical. And that's because the Rohrabacher FAR budget writers are medical budget writers. So that specific fact, being medical specific, makes the evidence a little better. But if I take that to the next step, we know full well the federal government is hands off, whether it's medical or adult use. And I think some courts have said that. And that, there's also the Cole memos and other evidence out there as well. So I think there's sufficient evidence to show that the federal government isn't really treating the two much differently. And in fact, if you look to okay, when has the government prosecuted under the Controlled Substances Act a marijuana business that's licensed under state law? I believe those are limited to medical companies, because those were all very early cases. And so we don't have any evidence that they're going after adult use cases at all, to my knowledge. And then Calvin, I take that couple steps further, and I would say that the Interstate Commerce Clause doesn't distinguish between medical and adult use, and the tax system would almost prevent that from being a factor. The tax system has sort of a big underlying principle to it that the IRS can't treat similarly situated taxpayers differently. And so there's a number of reasons why that distinction might not have legal significance, although I do think it is a factual element.
Makes sense. I've got a question here from, looks like a fellow tax preparer, asking about to what extent we could feel comfortable about the substantial authority and having at least 20% likelihood of sustainability.
Yeah, I think we're at 20%. Reasonable basis is somewhere between, I'd say, 15 to 40%. So somewhere in that range is where I think this argument lands. I've had a lot of people tell me they think it's on the high end of that argument. People that are smaller and more gray hair than me. I see the argument. I think it's a legitimate argument. I don't think that canon provisions would be a case out there right now unless it was. I don't think that Justice Thomas would have made his statements in standing akimbo unless it was a legitimate argument. As a matter of fact, we have one of 9 justices saying that Gonzalez v. Reyes may no longer be good law, right? And so that gets us above 10% right there, right? Yeah, I think we're somewhere in that range.
And then obviously the tax preparer will look at and review the tax opinion to make sure that they're comfortable with the arguments being made.
And Calvin, we can't get to 51. I think that's important for people to know. I mean, with binding Supreme Court precedent out there, Gonzalez v. Reyes is still good law. You can't get to 51%. And so you can't get to more likely than not. So this is a position that has to be disclosed. And if you're a public company, it has to be disclosed as an uncertain tax position on your financials as well, which is what we saw Trulieve do, right? And so they're trying to do this responsibly and trying to lead the charge and make a change.
What is the risk of a company that litigates this if they lose? What is the risk that Trulieve of 10 million in refunds if they subsequently lose in court above any beyond the 110 refund itself? Trying to formulate that question into
right. I think the basic risk is interest, and you have to pay the tax, right? But I think there could be some other risks that are important to say, however likely they might be. So first off, the IRS could find that the opinion was not correct, right? That it was a frivolous argument. They could take that position. You know, I think that they would lose that position, but they could take that position, in which case that would then mean if they won that penalties applied. And then also filing amended returns opens up the year for audit too, right? And that's not going to be just an audit of just this position. It would be a full audit, and the IRS could audit down to, you know, every little thing. And there may be some other things that they find that they don't agree with as well.
kind of rolling through these questions. Some of them are repeats.
You know, Calvin, I'll say this to the guy who asked the Chevron question. I would say that question is quite relevant in looking at 471C. That statute is very unambiguous. It basically just says there's this simple test, and if it's met, you meet the ultimate requirement of clearly reflecting income. And Chevron would say that an agency interpretation, contrary to the clear, unambiguous statement of the statute, was wrong.
Here's a question. How successful have you been in 280 audits to allow G&A expenses being deducted? I suspect the technical answer to that is, so long as it's a trafficking activity, there are no deductions allowed. So the answer is none. Maybe you've had some luck in convincing the IRS those were mischaracterized on a return as deductions, but were really immaterial costs that should have been included in cost of goods sold. But I'm answering for you, so maybe I should let you do that.
I appreciate you giving me that inside information there because we're talking deductions. Calvin's people talk deductions when they're talking cost of goods sold too,
Yep.
and so it happens, right? But yeah, no deductions are allowed under Section 280E, period. And that means under 471C as well. You don't suddenly get to start deducting things. So I think that the answer is if you are a 471A taxpayer and you are a reseller, you don't get G&A, period. End of story. If you are a 471A taxpayer and you're a producer, those would be the -11 regs, you get some G&A as applicable to your production activities. If you're in 471C, those rules under 471A don't apply, and we're not sure what you can get and not get yet, but I do know that taxpayers are putting G&A expenses into cost of goods sold, and I do know that some of them have received no changes after being audited from the IRS. Doesn't mean they're right, but it's not bad news, shall we say.
A question about attorneys recommending separate management companies, kind of going off topic here, but I guess I always advise against management companies as any sort of 280E mitigation technique.
Yeah.
I'm not an attorney though. I don't know. Do you have any thoughts on that?
Management company is a bad word in the cannabis space. If you're thinking about a separate company, first off, don't call it a management company, call it a consulting company. Second off, there's a case out there called alternative healthcare.
Yep.
That basically held that a management company that had control of a cannabis company was also subject to 280E. And so you're playing with fire when you try to create separate companies. There's a lot of companies that have done it. And Calvin, in the audits that I've had, it really what you just said, to get around 280E is the real question. If you're a 471A taxpayer and you're using a management company to get around 280E, the IRS has the right to recharacterize your company as subject to 280E because it has the right to clearly reflect income. If you're a 471C taxpayer, we're not sure if the IRS can do something like that. The jury's still out on that. And finally, Calvin, I'll say this, and I've had a lot of audits on this, and a lot of those audits have gone to IRS appeals and to tax court. And I have been able to settle a lot of cases where the IRS took a double 280E position by just agreeing to the 280E in the licensed entity. Once you accurately reflect the income in the licensed entity, there's no need to apply 280E to the quote management company. And so if you can get to that position, then the IRS will back off on 280E in the other company.
We're running out of time. I think this is a really good question. Does a protective claim for refund expose the taxpayer to other areas within the tax return? Assuming what their question really is does the IRS, does the statute of limitations for the IRS expand to all areas of the tax return if a protective claim is filed?
Calvin, I believe it does. It wouldn't though. Like I said, when you file a protective claim, the IRS doesn't even really look at the return other than seeing that it's a protective claim and then sending you this letter every year. I don't believe at that point that there would be any real risk of audit or an expanded audit or anything like that. But if you then told the IRS to process the return, they then could decide to audit it. And if they did, they could decide to audit the full return.
This question was Trulieve a 471C argument, or was it an argument of the Commerce Clause? I mean, I'll let you answer that. I would say if it was a 471C argument, it would seem to be a weak one, given that they have applicable financial statements because they're required to get an audit. So I don't know how you necessarily make that argument. So I think we're going with the assumption it was I think you laid out it was probably a Commerce Clause argument.
I believe so. It might have been a medical only Commerce Clause argument, but it was definitely not 471C because public companies can't use 471C, and neither can non-public private companies that have over 29 million in gross receipts. So it is the small business exception to the inventory counting rules.
Well, Nick, we're at our our 45-minute time frame, you know, we still have a number of questions. I don't know, do you want to continue trying to answer through some of these questions, or would you
Yeah,
like to?
let's take a few more.
Okay, I don't want to be rude with your time. What about hemp THCA argument? Does this come into play for Trulieve argument?
That one's really interesting, Calvin. I've been trying to learn the science on that one. I have no idea if Trulieve used that argument or not. It goes like this. Cannabis under the Controlled Substances Act, this Controlled Substances Act basically lists the plant, cannabis, as a controlled substance. And then if the plant is hemp, it's not a controlled substance. Hemp then is specifically defined as any cannabis that has less than 0.3% delta 9. So delta 9 is a very specific chemical compound that occurs in cannabis when it's heated. It doesn't occur very much in just raw cannabis flower. And so, you know, my clients tell me that they get their cannabis tested all the time, and it always comes back with no delta 9 in it. It has something in it called THCA. And when you heat or otherwise decarboxylate, decarb THCA, it turns into delta 9. So there's an argument then that because marijuana does not have 0.3% THC, or I'm sorry, delta 9 in it, that it's really hemp and is not a controlled substance. It's a remarkable argument. You got to get into the science a bit, but it flows really well just right from the statutes. And there's a case out of the Ninth Circuit that held that delta 8, which is an intoxicant compound, that the existence of delta 8 in what would otherwise be a hemp product did not take it out of hemp and make it a controlled substance, even though delta 8 is an intoxicant like delta 9. So there is some evidence out there to support the position that your neighborhood dispensary isn't selling marijuana, it's selling hemp.
Well, unless they're assumingly along that lines of thinking, edibles where it's already decarbed, then it would be a very
right.
Add a lot of complexity for tax preparation. So let's hope
Gummies.
this gets resolved by other
Which
ways.
Calvin is interesting, right? Because all the bad stories you hear about people having too much cannabis is because they ate too many edibles, right?
Yep.
And in a way, it is more dangerous, right? You can eat as much raw marijuana flower as you want, and you might get a bunch of antioxidant boosts, but you're not going to get high.
Yeah, probably maybe even nutritionally good for it. Who knows? I guess I don't know that for sure. One last question. If the DA hypothetically reschedules cannabis to Schedule 3, does this impact the review of the Trulieve amendment returns for prior years? Again, you know, acknowledging that we don't know precisely what Trulieve's position was, but
I think it's important to say that it would most likely not be retroactive. You don't see a lot of retroactive things in our system, particularly in the tax system. So if it was rescheduled to Schedule 3, it would likely only apply from that point forward, or even they could make a date in the future year for that. What we're hearing, Calvin, is that there's going to be an announcement this summer, or even maybe a little earlier, and then it's going to take a little while to get there. There's going to be a notice and comment period and stuff like that. It's going to follow the announcement. So we're thinking that we could see actual rescheduling occur towards the end of the year or 2025, in which it would, the first kind of possible year, I think reasonably speaking, is probably 2025 when 280E would go away then, if it was moved to Schedule 3.
yeah. Well, you know, I think I've worked through, I think most of them that were too terribly long or repeats. So maybe we'll call it a quits on the questions. Nick, I do want to say again, I really appreciate you taking the time to have this discussion. I know I learned a lot, and hopefully our listeners were able to get something this out of as well. But to our listeners, thank you very much for joining us, and everyone have a great day. Nick, I'll let you sign off as well.
Thank you, Calvin. Thank you, BGM. Look forward to the next time we do this together. Really appreciate the opportunity. And if anybody needs to discuss this, happy to talk.
Have a great day, everyone. Thanks a lot.
Thank you.